Right. Good afternoon, good morning, wherever you're logging in from. First, I want to welcome everybody to the MyFed University Estate Planning Made Simple webinar. This is backed by popular demand. Obviously, we've gotten a lot of questions since the last time that we have done an estate planning workshop here. And obviously, great questions that have been asked. And so we're going to answer a lot of them today. And we're going to go through a lot of information on how to really understand the basics of estate planning and what you need to help you and your family. We did this workshop back in October. We had a lot of federal employees request to meet with us and also to have their questions answered. So we're going to be able to do the exact same thing today. So again, welcome. If this is your first MyFit University webinar, welcome. If you've been with us before in the past, welcome back. We appreciate having you. So today I have a really special guest speaker with me. His name is Aaron Maassel. He's an estate planning attorney. And really, we brought Aaron on because when we partner with people at MyFed University, obviously we're looking for people who can really, as we've always done with MyFed University, take the complexity out of some of these topics that are tend to be so complicated. And Aaron does such a great job of keeping it simple. So I'm going to bring on Aaron shortly as we get started here. But obviously, it's great to have him on today, and I appreciate all of you. And here's what I want you to do. As always, if this is the first time you've attended this, what's going to happen is you're going to have the ability to get every single one of your questions answered. Now, obviously, we cannot do it live because there's a couple thousand people on here, and we don't know your specific situation. But what I want you to do as this workshop goes on, and Aaron's going to talk a lot about estate planning, is write down the specific questions that you have. Because at the very end of this workshop, there is going to be a survey that pops up. And at the very bottom of there, you're going to be able to put your comments and questions. We will answer every single one of them for you. I just can't do it live right now because, again, there's a couple thousand people here. So make sure that throughout this workshop, you're writing down specific questions you have. And at the very end, look, write us a book. The best thing that you could do is the more information that you have on specific questions, somebody from the MyFit University team will be able to get back with you and get your estate planning questions answered. Okay. So again, thanks again for everybody jumping on here. My name is Ryan Polimeni. I typically host a lot of these MyFit University workshops. Today I've got a very special guest speaker, Aaron Maassel, with me. He's the estate planning attorney that works at MyFit University all over the country. And I'm going to introduce him in just a second. I'm going to have him come on. But let me just go through a couple quick disclosures and disclaimers. So MyFit University is one of the largest federal education companies on the planet. Obviously, this is an educational-based workshop. So you're going to hear, obviously, Aaron, who is an attorney, talk about estate planning and taxes and things of that nature. Just make sure whatever you hear today, don't go run out and just do it. Make sure you seek counsel or you talk to somebody who's a professional that can help you with those things. This is general advice today, not just individual advice. So again, just a couple quick disclosures and disclaimers. Now, with the agenda that we have today, it's going to be pretty packed. But what we're going to do is we're going to take estate planning kind of piece by piece, break it apart so that you understand what estate planning is and how it helps you and your family. So we're going to talk about the overview, essential documents, what is really needed. One of the biggest questions that I get is, Ryan, what when it comes to estate planning, what are the documents that I need? What are some of the moving parts of this? What am I missing? Right? Sometimes, and Aaron's going to talk a lot about this. Maybe just used to have a simple will. Why that's just not enough in a lot of cases. So we're going to talk about that. Revocable living trust, estate taxes, and probate, and really then how you create your estate plan. And really leaving today, what you're going to be able to do is kind of build off of the foundation that we're building. So this is foundational pieces here, right? This is not it can tell you exactly what to do because we don't know your situation, but it is how you start bringing this thing together piece by piece, and then we're going to kind of summarize everything as we go. So before we kind of jump in, I'd like to introduce Aaron Maassel. He is an estate planning attorney. He's also an advisor, and it's very unique to have an advisor and estate planning attorney, under one roof because to be able to understand the financial world, the federal world, and to bring it in under the estate planning is very unique. So, Aaron, I'm going to have you just give a quick 1 minute introduction, introduce yourself, a little about your background, then we got a lot to get into.
Great. Thanks, Ryan. It's a real pleasure to be here. It's an honor to be here and talking to all you folks out there. I appreciate your time today. Hopefully, you find this information helpful. Yes, I've been an attorney for 21 years now, if you can believe that. At least I'm having a hard time believing 21 years practicing law. Primary practice right now is working with families, individuals to develop an estate plan based on where they're at in their life. And the vast majority of my clients at this point are retirement focused, either on the verge of retirement or who have made that jump and they're just getting going, or if they've even delayed further into their retirement years. But really evaluating where are you at in that phase of life, and what legal documents are needed, and how those legal documents then need to fit into, or what I talk about, how they are integrated into the rest of your retirement plan. And when we're younger, just like with investment vehicles and other investment tools, things change over time. And the same goes for legal plans. So, what was good for you when you were young in your 20s, just starting out in life, is going to be probably look pretty different what you need today, because of all the hard work you put in, the family you've built up, the things that you now have, and the things that you want to protect. And so, with all of that comes what I call stewardship responsibilities. And to be then a good steward requires you to do a little bit of work, do some planning. And part of that planning, what I believe is a foundational piece to the start of a good retirement plan, is having that right legal plan, so that all the rest of those parts and pieces, your income planning, your tax planning, your investment planning, your generational planning, all of that can fit into and work around that foundational legal plan.
Absolutely. And we're gonna dive a lot into that because, Aaron, one of the questions that I get a lot is, things like, for example, what what would be the difference between a will and a trust? And we're going to talk a lot about that and why would I need one versus the other. I think as we go through here today, those are a lot of things that we're going to hit on. And so let's kind of dive into it. So real quick, if this stat always blew me away, right? Is because just think about this. According to Google, some like a lot of the different researchers that we look at, 55% of Americans do not have a will or a trust, which what you're
Yeah.
going to talk a lot about is the exposure to what that leads a family to,
Right.
right? 34% of Americans only have a will. That means that basically there's several thousand people on this webinar, and that means that a third of them have just a will, right? Only
Yeah.
11% of people have a trust. So let me just start with this, 'cause I think it's important for everybody listening. A lot of people say, Ryan, Aaron, whoever, I don't need a trust. I don't have a lot of money. Why would I need a trust? So let's start with that, because I think if you look at these stats and you go, not a lot of people have, why would somebody need a trust versus a will, or both combined?
Right. So a lot of folks are given what I call, bad, well, just frankly, it's bad illegal advice or bad advice when it comes to this topic, because they feel that because I don't have, millions and millions of dollars, therefore my estate plan is not going to be complicated, and therefore I can get away with a simple will, or maybe I don't even need a will. And I can tell you that that general advice is some of the worst that can be out given to folks, because it, we all have things. We all have things in our world, whether it's investment accounts, bank accounts, your home, your cars, your boats, your motorcycles, even your precious moment collections, and your gun, whatever it is that you have in your home, your tools and all that. All of that I lovingly refer to as our stuff. And all of that has to be dealt with in some fashion when we pass away. And the purpose of the estate documents, the will and the trust, are there to guide your family, guide the courts through the administration, through the wrapping up of your things and your affairs here on earth. And it distributes those assets in a way where you are trying to lay out that framework.
Sure.
Because if you don't have those, which we can see half of Americans don't,
Right.
a third of us only have a will, what happens? Well, the state where you live has a plan for how your affairs are going to be wrapped up. So if you live in Virginia, to Maryland, to North Carolina, to California, to wherever you are, the state where you live has a law of intestacy that says if you pass away without a will or without a trust, we, the state, will determine who your heirs are. And those heirs most likely are not the heirs that you think they should be, or the ones that you would choose. So really, by leaving it to chance as to where your things go, you're really letting the state dictate that in your life. And most folks, who after they realize that and they talk about that, they have different ideas about where they want their things to go.
Absolutely. No, that's awesome. So the thing is, like, when I look at this, and for a lot of you, in estate plan, you have to think about this differently. In estate plan, right, people think about wills, trust, but it is really the sum of your total assets working together because you have the legal and the financial integration. So when we look at this chart, um, how many of these bubbles, right, can you, for those of you watching, how many of these bubbles can you check off? Because an estate plan is all of these things moving together, right, working in harmony with each other to have an end goal, right? Which is to make sure that either while you're alive, your affairs are in order, and when you're no longer here, they are protected, right? So, I mean, look at this. What are some of the things that you see that stick out on this that people typically miss that are important?
Yeah, the main thing that you need to understand is that a good legal estate plan involves more than just one or two documents. It's not a simple will and you're good. The will, the trust, and some of those ancillary documents like that are there to handle your estate when you pass away. And we're going to talk a lot about that today. But good legal planning is also going to create and implement documents that are going to work for you while you are alive. This is where the living will comes into play. This is where a healthcare power of attorney and a general financial power of attorney come into place. And you can see here, who makes medical decisions for you if something major has happened and you are incapacitated. You are not in a position to talk and communicate about your wishes and your desires. Mm-hmm. Having a healthcare power of attorney is you, when you enact that document, appointing an agent to make those medical decisions for you on your behalf when you cannot do it for yourself. And obviously, we talk about who that should be. Usually, it's somebody you love, you trust. Right. They're going to make good decisions. Right. Yeah. They make good decisions for you for your betterment. And that's important because now you're eliminating confusion. Sure. And most importantly, you're eliminating oftentimes court involvement in those ugly type of scenarios, because obviously in emergency situations there can be emotions involved. And so by ordering your affairs and listing out who and what happens and when certain things take place in your life, you are bringing order out of chaos. Mm-hmm. And you're really doing that to better your life, but better for the betterment of your family as well.
And what I like about this is you think about when a lot of people think about estate planning, look at all the pieces on here. It is your taxes, right? And so many people think about, when if I don't have a will, if I don't have a trust, is how do I pass things more tax efficiently to my family, right? You look at charitable contribution, trust, wills, the executor, things you were just talking about, insurances. So many people have just, you look over to the left, right? They got the living will and maybe a funeral policy or a small, but like there's so many more pieces to this.
Yeah, absolutely. And that goes into some of the other documents, and the creation of the trust, the creation of the will, and how those documents, once they're created, integrate into what you're trying to accomplish. Appointing the right people as your executors and your agents, having a plan to effectively pass assets on to those heirs at a point in time where they are ready and safely capable of receiving those assets. That's distribution planning. Talking about charities, churches, things that are important to you. How do you benefit those as part of an estate plan? And everyone's favorite, how do I deal with taxes and making sure that my assets that I have saved up and built up are going to now pass on to my family in the most tax efficient process? Because all of that, when you look at assets and how you administer those, and how they are going to work for you during your life, integrating them as part of that legal planning is absolutely key.
Absolutely. So let's talk about some of the essential documents. This is important because, again, as I've done these workshops all over the country, we just did 3 of them at the VA hospitals, and this is such an important topic. Help us break down the differences between the financial power attorney and the healthcare, because I know sometimes these kind of get intertwined with people, but they are very separate things.
Yeah, well, absolutely. And so, this is a good one to start with, because these are documents that will actually do something for you when you are alive. These documents grant authority to a separate person to take certain legal actions on your behalf when you are not capable of doing it yourself. And so the first one we have here is a power of attorney of finance, or this is typically called a general financial power of attorney. This is where you are nominating and appointing an agent to stand in your shoes to take care of the financial affairs in your world. And depending on how broadly you write these, will depend on all the things that your agent can do.
Sure.
I'm typically a fan of writing them very broadly and just being wise about who you are selecting as your agent, right? Because if there is something that you need done from a financial perspective and you are still alive, but it needs done, your financial agent needs to be empowered with this document to be able to go do those things. And we're talking about things like filing your taxes. That's coming up right now. God forbid we are late on filing our taxes here, right? Um, Making investment decisions, paying our bills, all of those types of things. Getting our car insurance in place or renewing our tags. These are all things that can be empowered to an agent through a financial power of attorney, so that while and if you are ever incapacitated, your financial house is not going to fall apart.
Sure. No, absolutely. And then the healthcare.
Yeah, the healthcare is everything else outside of the health or the financial related world. So again, so something happens to you medically, you are not in a position to make these decisions. You're in a coma. You're somehow incapacitated. Who is going to make those medical decisions about care that you are going to receive? Sure. Whether that's treatments, surgeries, placement into different facilities, um, figuring out how to cover the costs of those with your insurance companies. All of those things are things that are covered by the healthcare power of attorney, and you are you're nominating an agent to make those decisions. You're in taking chance and confusion out of it, otherwise what could be an emotional situation, right?
Sure. So, Aaron, a question that I get often when I'm doing these workshops around the country, and even through the last, MyFit University ones, is what happens if I don't have somebody appointed?
Great question. So there is a process, and it involves the courts. And the probate court is there to do a lot of different things. And one of those things is to deal with what are called guardianships. And in the event you are incapacitated and there is not agreement amongst your family as to how things should be handled, a hospital, a financial institution isn't going to have any kind of direction or guidance as to who they should be dealing with and who they should be listening to. And so a guardianship action is in place to then open up for the court to nominate who those agents are going to be. And then those agents are actually then going to be responsible back to the court and accountable to the court for all of the decisions and all of the actions that they've taken on your behalf. And so think about that for a minute. A court action has to be filed. First of all, you have to deal with all the drama on the front end amongst the family. Then somebody has to get angry enough, or there's enough chaos in place to actually run to court and open the guardianship action. Somebody has to step up to want to be in this place. And if more than one person is stepping up and vying for that position, now the court has to weigh who is in a better position to actually be appointed to serve. Okay. So you can have some contention there. And then ultimately, once the court makes that decision, that agent then is empowered. Now they can finally go out and do these things on your behalf. But they also, like I said, have to report back to the court. There's fees, there's times, there's delay, all those things involved through a guardianship action. There is a process for that, but I don't recommend that being your default strategy as we do this.
So one thing that I've heard you talk about a lot, and I don't think enough people think about this, right? Let's say that you have children who are even minors, but even let's just say that they turn 18 and they are still in college or still under your roof, immediately getting a power of attorney put in place for even young adult children.
Well, sure, yeah, because once they're adults, they are legally their own person. There's no longer that parental guardianship over our kids at that point. I mean, they're always our babies, right? But you don't have that legal separation any longer. And so your 18-year-old, your 19-year-olds, they can have bad things happen in life as well, unfortunately. And so those folks would be just as much in need of these for those life emergency situations as those of us who are in our 50s, 60s, 70s, and beyond. So
absolutely, no, that's helpful. So, all right, let's talk about the will. So, obviously, this is probably the most common thing when people think about estate planning. They think of, oh, I've got a will. So let's break down what a will is. And I know we're going to get into the trust. We get a lot of questions on that. So break down the will. What is a will? What is it built around, and why does somebody need one?
Yeah. So probate as a court. So we talked about the guardianship that probate can get involved in, but the probate court is also there to ensure that people's affairs are wrapped up at the end of our life. And so that's the probate process. That process, the court will require people to declare assets, list all the things that you have in your life that you own. They will ask creditors to submit claims of people you may owe money to. And then ultimately, the court will say, who are your heirs that then are entitled to receive those assets? That is probate in a quick little nutshell.
Sure.
The last will and testament, which is the most common legal document that's out there, is a probate document. It is not a document that is used to avoid probate. It is a document that is used to guide the probate court through that probate process. It is informing the court as to what your wishes are through as the court is administering your estate through probate. So common things that you see in a will is you are nominating your people to be who you want to be your executor. This is the person who survives you and then is in charge of gathering up all the information about your estate and all that kind of stuff. That
Sure.
You are making that nomination of who that party is in your will. You are nominating who guardians of any minor children you would have in your will. You are also making declarations in your will of who you want to benefit from your estate. Now, all of those are things that you are wanting. You are expressing your wishes to the judge. Ultimately, it's the judge who makes all those final decisions. So your executor, you may be not nominating your wife to be your executor, but if you're in the midst of a divorce or some other ugly life situation is happening, the court's probably not going to follow the wishes in the will.
Sure.
They're going to go a different direction. And same with each of those different categories. There's different rules about how the court must administer it, but the purpose of the will is to inform the court as to what your wishes are as the court is going through that probate process.
Absolutely. And I got to tell you, I know one of the things about a will that people ask all the time is it enough? Is that all I need? Why do I need more? But think about one of the things I know that you talk a lot about is the contestability of a will. So kind of to your point, right? You have a will, it becomes public knowledge.
Yes.
And then all of a sudden you have a cousin or a family member that you haven't talked to in a long time that all of a sudden you die, they think that they're entitled to something now. And what do? They come and contest it. And what is that? What happens in that situation?
Yeah. So typically contested wills happen amongst our kids. And that's one of the saddest things in this area of law that you see is the large estates that are then going through probate, kids contesting that, arguing over the viability of the will, the equity of the division of assets, competency of mom or dad when they sign the will. All of those are issues that are subject to a contestant action, and probate court invites that. Yeah. That's the purpose of the probate court. They are asking people to sign waivers. Yes, we are okay with my brother Bob being the executor for dad's estate. Well, if I don't like Bob, if I know Bob is a bad financial investment handler of his own affairs, I certainly don't want him handling my mom's estate.
Right.
I'm going to step up, even though mom wanted Bob to be the executor. I'm going to step up and say, no, if mom knew what I knew, she would not go along with Bob. And so now we have a fight over something as simple as who is going to be the executor.
Good. No, that's helpful because I mean this is something obviously that we get a lot of questions on, and obviously some of the benefits. Now, let's talk about as a legal guardianship because I know a lot of people listening in have either young children, minor children. How does it work in the legal guardianship of a child in a simple way?
Yeah. So again, you're making nominations as to who you would want to be guardians of your minor children should something happen to you. If you have not made those nominations, the court has really nothing to go on. So people will come in and apply to the court through probate, through a guardianship action to be that person. And so really having these types of things listed out if you have minor children is important because it's giving good guidance to the court as to what your wishes are.
Perfect. Now, here's the thing, Aaron, right, is we talked about a will just now. People ask me all the time, and I get a lot of questions. We get a lot of questions from federal employees as we do these is, why would I need a trust versus a will? Let's talk about what a trust is, and then what are the differences and how do they work together? Because when you talk about legal planning and financial planning and the two of them having to work together in harmony, this is really where you get in depth with financial planning because these are tools that help in the financial planning. When you hear people talking about how do I pass assets in the most tax efficient way, right? This is where we begin that planning process in the trust. So let's talk about what is a revocable living trust, and then why would somebody need this and a will?
Yeah. So back up quick of why people want to avoid probate in the first place, right? I mean, some of the things that we've highlighted here are only but a few of the problems that come with probate. The length, the expense, the potential for conflict. All of those are reasons why people want to generally avoid probate as much as they can. And so then you're looking at what are the best legal tools available to people to do good planning to then avoid probate.
Yeah.
Trust planning is one of those tools that is available to people to then use and avoid probate. What is a trust? In the most basic form, a trust is nothing more than think of it as a bucket that is created at the time that the creator signs the document created by the lawyer, hence the bucket is now created. And the purpose of the bucket, i.e., the trust, is to hold assets either when I put them into the trust when I'm alive or when they pour into that bucket when I die. And then how those assets are then removed from the trust or distributed out of the trust bucket is going to be based on the language that I lay out in that trust document itself. And so the purpose of the trust is to again, create an entity where you can put assets while you're alive or when you die. When you then pass away, those assets in that trust are not going to be subject to that probate process. All of that stuff we were just talking about with probate can be avoided if a trust holds and owns those assets.
So, Aaron, what is the typical asset that you see that? Because I know a lot of people, language is difficult when it comes to estate planning. I mean, you hear funding a trust, right? What are a few of the most common assets that you see people put into the name of a trust?
Well, certainly one of the most common one is real estate, people's homes. I mean, it's usually oftentimes the largest asset that we have, and we want to make sure that that is handled effectively, avoiding probate, avoiding creditors, all that kind of stuff. By funding your home into a trust, we're essentially what we're doing is we're moving legal ownership of that property out of your name and into the name of your trust, so that now it's going to be governed by the terms of your trust, which after all, you can benefit typically from these trusts. So you can still live there. You're still responsible for cutting the grass and washing the windows, but you now have a legal entity in place that if and when you pass, there is a plan to distribute that asset outside of the probate process. We don't have the cost, we don't have the delays, we don't have the potential for fighting, and we have specific guidance as to who should then benefit from that asset once you've passed away.
And I know one thing that you've talked about a lot, and some of the questions that I get too is, with a lot of people listening in that maybe they have either younger children or children that are in their 20s and 30s, right? You talk a lot about why somebody should have this built into the trust where you can distribute assets at certain times of your young adult children's life. Because let's be real, the average inheritance is going in 18 months, right? Why? Because you have a 20-year-old that's inheriting $500,000 and they lose his taxes.
And we all know where that money is going to go when the 20-year-old gets it, right? The car dealerships, the boat shop, the video game store, that's where those things go. So yes, I want my kids, my family, my younger family to inherit from me, but I want them to do it at a point in time where they are responsible enough to do it, where they are in a good place to receive it. And that may not be when I die. I'm sure it's going to be an inconvenient time for me when I pass, and I want to make sure that my timing on death is not going to impact the value of my estate as it goes to my children, and most people feel the same.
Okay, good. Now, I love this slide because you see there's so many of these moving pieces to a trust, right? The terms agreement, the trust itself, the property, the beneficiary, legal, all that stuff. And it's confusing. It's complicated, a lot of this. So I want to make sure I remind everybody again listening in, as always, I know a lot of you probably have a lot of questions. Make sure that you are writing your questions down, because at the end of this, you will be able to get your questions answered. And I know a lot is going to pertain to you personally. So write that stuff down at the very end. There's going to be a survey that pops up. Write a book to us. It helps us so we can help you. All right. So here's some different definitions, and I know you've hit on a few of these. So some of the most commonly used definitions, right? You have a grantor, you have a trustee, the beneficiary. Right. Walk us through a little bit of the differences between these, because this is confusing stuff when you don't know who fits what model.
Sure, and this, legalese, lawyers are great at this, right? So understanding terms is important here. So the grantors are the people who create the trust. So those people, go back to my earlier example, creating the bucket. These are the people who sign the document, create the document. It's usually also the people whose assets we're funding into the trust. Now, there's all kinds of trusts out there, and you can set them up about different creators and things for different purposes. But for 90+% of the time, we're dealing with, a husband and wife are entering into retirement. They want get a good planning in place. They are going to create this trust. They are going to be their grantors.
Okay.
The trust then operates in pretty much two distinct phases based on the grantor's lives. It will operate under rules number one when the grantors are alive, and it will operate in another fashion once the grantors have passed. Usually that is the distribution phase of the trust life.
And then the trustee.
Yeah, so once the trust is created by the grantors, the trust is its own entity. It's whether it's a revocable trust and it's still kind of affiliated with the grantors or not, somebody has to be in charge of it. And trust, keep in mind, trusts aren't owned like businesses. They are kind of they exist, and there's this quasi separate legal entity situation. Somebody has to be in charge of it. That is what the trustee is. So I kind of allude to this and liken this somewhat to like a CEO, but it's the person who is in charge of the trust, running the trust. They are empowered to do all the things that the trust is allowed to do, managing assets, all that kind of stuff. And for most of the time, I would say almost 100% of the time, the grantors, when they create the trust and fund the trust with their various assets, are then also going to be running the trust as their own trustees.
Got it. Okay. And then, so what's a beneficiary and how is that different? You hear beneficiary forms on TSP, right? And our different insurance policies. Is that similar in this?
Yeah, somewhat. But, with a trust, as I said before, trust will operate in two distinct phases. And so when we talk about beneficiaries in trust world, there's what are called lifetime beneficiaries and then residual beneficiaries. The type of beneficiaries that you see on TSP forms, life insurance, those would be like the residual beneficiaries. They get what's left of the assets that are in the trust when the grantors have passed away. So I say they get what I call the leftovers.
Sure.
But the lifetime beneficiaries are those who are entitled to benefit and enjoy the assets that are held inside of the trust while the grantors are alive. So if a husband and wife create the trust and they're running the trust as co-trustees and they're putting all their assets into the trust, we'll take a guess as to who the lifetime beneficiaries are. But it's going to be themselves, right? Because it's their money, it's their stuff. They just are doing some good planning around this, and they want to make sure their affairs are wrapped up when they pass. But while they're alive, this is still their stuff, and they should be using it. And this is a mechanism for them to still have access to those things.
If somebody has a beneficiary form filled out with their TSP, does that override the trust?
It does, because in order for the trust to take control of an asset, it has to fund into that trust. And so with a beneficiary designation, if you are not naming a spouse or children, those assets never get to the trust in the first place. And this is where bad legal advice from non-lawyers often comes into play, because they will say, well, you don't need a trust because you can avoid probate and get assets to your family with beneficiary designations. While that is true, what that fails to address is the other side of that coin, which is the ugly side of that coin. And the ugly side of that coin is our beneficiaries on those types of designation forms may not be in a good position to inherit those assets when you die.
And that's what we're going back to talking about in the trust. You can say, hey, I would like I got a 25-year-old son, right? I want my 25-year-old son or daughter to receive their first, maybe a third of my assets at 25, then maybe the next third at 30, and you can designate times when your beneficiaries can receive different hits versus, right, if it's just on a beneficiary form, they got a 10-year rule or they're getting all in one shot.
In my opinion, Ryan, this is the one of the top two benefits and reasons to get a trust for this exact reason. And you are exactly right in how you just described that. With a beneficiary designation on a TSP or any type of investment account, when you die, that account, the value there is going directly to that named party. And it doesn't matter what is going on in that person's life, it is showing up in their world. And so hopefully, and most of the times, people are fine to get that, but hope is not a plan. Hope is not a strategy I'm a big fan of. And so when you go through the parade of horrible things that can happen in life, divorces, bankruptcies, lawsuits, tax liens, all of this ugly stuff, major medical things. Yeah. Those things happen to our heirs, our kids. And, as bad as we may want to not think about that, as much as we may not want to think about that, it does. And so if our children would inherit through a beneficiary designation, that asset of yours, which is now theirs, is now subject to all that life ugly that is going on in their world. Because there's nothing stopping that beneficiary designation. The purpose of the trust and pointing beneficiary designations to your trust is for that, what I call that controlled distribution out of all of your assets, out of your trust to those same beneficiaries, but it's being done in a way through controlled planning, controlled distribution, so that you can ensure, or the trustee at that time can ensure, that my sons are in a position to receive those assets. Those assets aren't going to be in danger when they receive them.
Perfect.
One of the most important parts of the trust right here.
Right.
So, yeah.
And so really obviously, what you were just talking about, right? The benefits of living trust, avoiding probate, not, and again, not always completely, but it helps avoid a lot of the probate that you were talking about.
Yep.
Generally more, considered more difficult to attack in court. What you're talking about, it's helping kind of put that wall up between you and maybe some of the people you don't want, right? Because you can disinherit people and things of that nature.
Yeah. So through probate, people have certain legal rights to your estate, and so it's the court is inviting those challenges. It's asking for people to, if there are disputes, to have it out. A trust is considered a private contract, and so you can dictate the consequences of challenges. And oftentimes, one of the biggest causes to mitigate any type of challenge is a disinheritance clause that says, hey, if anybody wants to challenge the viability of this trust, if they're a named beneficiary, they're not going to inherit it if they try and challenge this. So that has a pretty cooling effect on litigation out of a trust.
Perfect. Yeah. Now, again, probate. We hear probate all the time, and you've talked a lot about that. And, that's one of those things where to avoid as much as possible is great. But for a lot of people, Aaron, a lot of people say, well, look at how high the new 2026 estate tax update is. Meaning, so let's kind of explain this. I know that we get a lot of questions on this. Let's explain a little about what these tax exclusions mean, because when I see this, a lot of people say, well, does that exclude everything? But not really, right? Because if you have a traditional TSP, traditional IRA, that is a pre-taxed account, guess what's going to get taxed?
Right. Those account, and so this is where, again, looking at the types of assets you have, the value of those assets is going to be very much have an impact on the type of legal planning you should be doing. And this plays right into the integration aspect of planning. And so it's important to understand that it's important for the attorney to have an understanding of the types of assets you have, the value of those assets, and what you're intending those assets to do for you into your retirement years. That's why legal planning in retirement is going to be different than legal planning in your 20s, 30s, 40s, and 50s. With this issue regarding the federal estate tax issue, this is an issue regarding that focuses on what a tax would be on what the federal government has dictated to be a large estate. And if you are a single person and you have more than $15 million in your total estate when you pass away, those assets above 15 million are going to be subject to that federal estate tax, and it very quickly gets up to 40%. So a lot of people are looking to avoid that. Now, it takes a little bit of work to get to $15 million. I can tell you, I'm not quite there just yet. I'm not sure about folks here, but and for couples, it's $30 million. And if you're married, each spouse can use the remaining of the other spouse's unused portion of that estate tax exclusion when they both pass. So you have that full 30 million if you're married. But that's more of a federal estate tax avoidance. It doesn't apply to most folks.
I got you. So now I think that we started to kind of paint this picture of what a trust does and will does. What is, so you've been a probate court. You're an attorney. You've gone through a lot of these. What does that look like? I mean, obviously, I know that's time consuming. Yeah. It's incredibly expensive, right? It can be, and it delays a lot of the disbursements and distributions.
Yeah. So probate is that process for administering your estate. The court is involved, the judge is involved in doing that. And it's a kind of the regimented process to do that. With that regimented process is a time to allow creditors to make claims, and so therefore, the court process itself is naturally stretched out longer than most people think is necessary. So simply to give potential creditors out there an opportunity to make a claim against your estate. Yeah, I can tell you most states right now, you're looking at an average probate case length of about 18 months is a good kind of rule of thumb for expectation purposes. Simple estates obviously can be done much quicker. More complicated estates where there might be litigation involved can obviously drag out much longer than that.
But and that's what we were talking about with
right.
people contesting.
Right.
You know, now you got that issue where it's just dragging on forever.
Right.
And listen, I know we have a couple thousand people listening right now. I can guarantee if we went to a few of these people, they've got some stories to tell about probate.
Sure. We all have, whether it's dealing with mom and dad, a sibling, a grandpa, grandma, we've all seen some of those things in action, unfortunately. And maybe you weren't in the weeds with it, or if you were, you would really understand some of the detractions of probate. Not only the timing, but the fees involved, legal fees, court fees, appraiser fees, professional fees. People don't realize probate court is a court of public record. And so oftentimes, pretty much everything that is filed, including the will, is all subject to public review. So your nosy neighbors can go down and take a look at things. If you have business people, they can go down and look at accountings and appraisals. So there's a lot to avoid, a lot of reasons to avoid probate for some of those detractions.
And that's what you talk about with the trust.
Correct. And that's really what the trust is there to do. And so the trust is an alternative legal tool that's used to distribute assets out of your estate to where you want them going in that controlled fashion, avoiding that probate process.
And does it help keep things more private?
Oh, absolutely. The whole purpose of the trust is it is a private contract. It's not put on file, and the details of that trust are really held internally with the family.
Perfect. So again, we talked about living trust allows you to quickly and easily transfer property, right? We talked about that without the time and expense of probate. And I think that this is, for a lot of people, Aaron, their home is probably going to be one of the biggest assets that gets transferred, right? And if they don't do this, what could happen if they don't have their home? And some states are TOD. There's a lot of different ways to do this, right?
Absolutely, there's. Yeah.
But what do you see the most when it comes to home transfers?
Yeah, I mean, there are other mechanisms. Those are the TODs, the PODs. These are beneficiary designation types based on different asset classes. And so trusts are not the only way to avoid probate, but they are the only way for that controlled distribution. And so by utilizing trust for that distribution, you're really ensuring that your plan on your asset, your home in this situation, is going to go and follow those rules, that plan that you have set out. You're taking chance out of play here, and by dictating this through the trust directly.
Perfect. Now, all right, so let's talk about we've gone through a few of these. So the estate documents do you need? So Aaron, obviously if somebody says, hey, listen, I need some help putting this stuff together, I don't even know where to begin. Let's kind of go through some. I know we've touched on these, but these are some of the documents that are going to be most important, right? And when we first started and we looked at that chart, and we had all those bubbles, right? Now you can go, how many of those bubbles do you have checked off? Right? If you just go through here, so many people that I've met with, in the advisory world, work with federal employees for 16 years. People come in, I got a will, I'm good. Well, what about your power of attorneys? We don't have those, right? What about your health care? What about, and I think that it's important that everybody kind of looks at this and starts checking off, what do I have and what do I not have? Because these are important documents. We talk about planning in general.
Yeah, absolutely. And so touching on these, and again, whether everybody needs, especially when we get to the trust, is a case-by-case decision. So don't take this to say that you absolutely need this, but it should be part of the evaluation in designing your estate legal plan, especially as you are approaching retirement. But so under the powers of attorney, these are those advanced directive documents, the financial power of attorney, the healthcare power of attorney. One that is often added to this mix is called a living will. And this is you making your own end of life decisions for yourself with another third document in this section of documents here.
Gotcha. So
those are pretty much basic documents that are put in place fairly commonly. The last will and testament, we talked about that quite a bit. Even if you end up doing trust planning, chances are you're still going to want and need a last will and testament. It may be a different type of will, and it would be a will that would be designed to specifically work with that trust. But you're still going to want that. You're still going to want a document that conveys your wishes to that probate court, should even an abbreviated probate court process would be necessary.
Yeah. And again, as we look at this, you've talked about it so many times, the integration of legal and financial. And I
Right.
know you've been an attorney now for over 20 years, and as you see people come in and you go, wait a minute, so you got your will, maybe you have a trust, but what about the financial? What about the tax planning? What about all the, how do you have all these? And a lot of times you've told me, as Ryan, I don't even see a lot of people with their, maybe they have an attorney, maybe they have an advisor. They've never even they've spoken to each other.
This topic right here is why I got into the planning business as opposed to just the legal business. Because from an experience in my own family, my grandparents owned a longtime family farm. It had been in our family generational for over 100 years at this time. And my grandparents had put a trust in place specifically to protect and deal with the distribution of the farm. But when it came time when my grandparents were passed, when my grandfather passed, and we were dealing with that issue with my grandmother still being alive, we discovered then that the trust was not properly funded with the one asset, the farm that they built and bought the trust for in the first place. So it was coming out of that I said, oh my goodness, how many other people are in this same situation? People who are trying to do good work, good stewards of their assets, have gotten advice from good, competent professionals, but it's that lack of integration, that lack of communication between professionals, where you now have gaps, where you have a real fancy legal tool sitting up on the shelf gathering cobwebs that's going to do nothing for you because it has not been properly integrated with your TSP, your IRAs, your 401ks, your investment accounts. All it, a lack of integration 9 times out of 10 is going to result in a fail when it comes to the legal plan.
Sure, because you think about a lot of federal employees are, they think about, all right, do I do Roth? Do I do traditional, right? And even something as simple as that is when you were just talking about, people think, well, if I have it in the trust, is my TSP traditional going to pass tax free? How do I? But the answer is no. And the thing is when you start to look at this, you go, Roth is going to pass to, your family tax free. And then when you go, what about the planning part? That's for things like Roth conversions. And you start looking at, that's why I said, right, is the estate is all of your assets in a whole.
That's right.
And they all have to work in harmony with each other. Just because you have the trust here, but you haven't done any tax planning, what about doing things like Roth conversion or doing Roth so that in this situation, your money is being passed tax free to your family, right? There's so many different ways to be able to integrate those.
Well, and tax free is that's in the financial side of it. But how that then passes through the trust is, how do those investment vehicles, the Roth account, the TSP account, the after tax account, how are those properly integrated and working with the legal documents? Yep. And this is why it's important for the attorney to understand what the financial planner is doing, what the investment advisor is doing, what your insurance agents are doing, and for all of those folks to have a good understanding and comprehension of the tax implications of all of this. Yeah. That's what integrated planning is all about.
Makes sense. So here's a couple of things that we've always talked about too, is Medicare and Medicaid. I know that's a whole nother world in itself.
We can talk another hour and a half on right, Medicaid if we wanted to.
But I mean, obviously people hear Medicaid spend downs. And so obviously there are different types of trusts that you can utilize, like irrevocable trust that can help with things of that nature. But we look at all these different withholdings for distributions, provisions for minors, ability to modify. Because the thing too is if people say, well, Ryan, if I have a trust, can I change it? Can I make changes to it? So talk a little about maybe, if somebody has a revocable trust, what is their ability to make changes regularly?
Yeah, so with the revocable living trust, part of the reason why that's the most commonly used trust is the flexibility that comes with that trust. Now, there's some detractions with those types of trusts in that if you're looking for asset protection, specifically regarding Medicaid, since you brought that topic up, there are going to be some deficiencies with what that trust will do for you for Medicaid planning. So again, it's understanding what clients' circumstances are, what their desires are, the types of assets they have, to really truly be able to evaluate what is the right type of trust for them based on all the answers to all those questions. But with a revocable living trust, that's the most commonly used trust. Again, it's the primary purpose of that is a probate avoidance and that controlled distribution. Those trusts are very user friendly. If you want to make changes, if you want to now add your grandkids into your distribution plan specifically, you can very easily do that by amending your beneficiary section. If you happen to move from Pennsylvania down to Florida because you're tired of the winters. You would want to change what is called the situs of your trust, which is the state laws that'll govern the implementation and the review of that trust. All of that is very easily done with the revocable trust. There's a lot of flexibility there.
Okay. So let's kind of summarize this, 'cause I know this is a lot. And listen, I know once again, this is a lot of information. And what I want to do is I wanted a lot of people here to hear some of the things that maybe they overlook or some misconceptions or common questions out there. Here's what I would say is everyone should have an estate plan. But to your point, it doesn't mean that they have to have a full-blown trust package. Maybe it's not right. But do you have the proper documents in order? Do you have the will, the powers of attorney minimally, right? Do you have the financials working in conjunction with this? Is the tax plan conducive to what your estate plan is?
Right.
Those are going to be important. Here's the other thing too, is when we talk about planning and reviewing often, Aaron, there was a big change that I want you just to hit on quickly with this thing called stretch IRA.
Yeah.
And how that went away and how it's going to affect a lot of people, because we get a lot of questions on Ryan. How much time do I have? What are my kids going to be able to do? What was the stretch IRA and what is it now in 1 minute?
Yeah. So prior to 2019, if a non-spouse inherited a qualified account, a pre-tax account, like a TSP account, they would be able to take distributions from that account based on their own life expectancy. So if I'm 45 years old when my father who passes away, I presumably would have, call it 45 to 50 years left in my life. So therefore, my distributions from my father's inherited TSP account would be stretched out over those 45 to 50 years. Under the new rules, under the elimination of the stretch IRA, I no longer have the ability to stretch those distributions out over my lifespan. I now have to take those distributions out over a 10-year period of time. And so, and when I take those distributions out from my father's pre-tax account, that is added to my bottom line income today. And so, at 45, 50 years old, I'm not throwing hay bales around like I did when I was 16. I'm not flipping hamburgers. I'm not delivering pizzas. I am in the prime earning years, which is where most people are when they inherit something from mom and dad. And that means that not only am I already at the peak tax brackets for my earning years, but now I am inheriting money from mom and dad that's also going to be treated as taxable income, subject to those same tax levels of where I'm at. And this is where we talk to mom and dad to say, who's in a better position to pay the taxes on these accounts?
Yeah.
Your son, the attorney, who's at 35% tax bracket, or you who's drawing Social Security and a pension and you're sitting at 15% bracket. Sure. Who's in a better position to pay that taxes for tax efficiency purposes? Right. And it's the obvious answer is mom and dad, but the part that people get wrapped up in is nobody wants to pay the taxes. They don't need the money. They're frugal. They're happy. They don't need the extra money. They want to see it pass on. But by delaying, you're creating a tax time bomb for your family when they run into this inherited IRA tax issue down the road.
And then the 10-year rule applies to everybody or everybody other than a spouse?
It's everybody who's not. So spouses still have spousal inherited IRAs. So that 10-year distribution rule does not apply to them. But anybody who is not a spouse, when they inherit that money, including, well, we'll just leave it at that. For not a spouse, they are going to be subject to that 10-year distribution plan.
So mom, dad, children, brother, sister, anybody if that's inheriting, anybody other than a spouse.
Who you are not married to is going to be subject to that.
Yeah, absolutely. So here's the thing. Here you have a couple options, right? You could do nothing. You can keep putting it off, which a lot. And I think what's
the state has a plan for you if you do nothing.
But what's hard for a lot of people, right, is that when these things are this confusing, it's what they do. They do nothing. Mm-hmm. And you could put it off. Which for everybody listening, again, for those of you listening, you have a lot of questions, I'm sure, because Aaron has just brought up a lot of different things probably you've never even thought about. Make sure at the end of this workshop you fill out that survey. Write a book to us. Aaron's going to be looking over these questions, and somebody from MyFed University will be able to work with you and get those questions answered. So you don't have to worry about that, but write that down. Because stop putting it off. Yeah. Right? Don't do anything.
The ostrich plan does not work.
Right.
The head in the sand plan.
It doesn't because it gets you, wrapped up in certain things. You could do it yourself. Look, there's a lot of do-it-yourself platforms out there, right? It's LegalZoom and all this. Unless you know the laws and the rules of your state and the federal, that can be tricky. We'll leave it at that. That can be tricky.
It can be tricky, and you don't know what you don't know. So the things that you think are available are not maybe the best things that are out there that are actually available for you.
Right.
So that the do-it-yourselfers are just they find trouble through ignorance.
It's unfortunate, and not because they don't know any better, just they don't know any better than that,
That's right. That's right.
And then you could use a local attorney.
Yep.
And Aaron, on like what's a national average for somebody that does a full-blown like a full-blown estate planning package?
You're probably, I would say, depending on the complexity of the trust and ultimately where you're falling with that type of planning, because that's really where the complexity comes in. Yeah. You're in somewhere the 2,000 on the low end to maybe 5 to 7. I've seen trusts, very complicated trusts, upwards of $10,000. But most folks are in that, what I would say, $2,000 to $5,000 range.
Okay, got it. The other thing too is, look, again, we have a network of people that we can help with MyFed University. So again, if you have questions and you need help, let us know. Here's a couple things that we have. So let us know if you need help with anything. You can obviously always reach us at info@MyFed University. Call us at 919-706-1846. But the best thing to do is fill out the survey that's going to pop up. Ask us your questions. We will get somebody to answer your specific question and give you some guidance along what of these things make sense to you and your family and how we can help do it in the most tax efficient way. So Aaron, I want to say thanks so much for being on here, man, and helping us out and give us some information. Any questions, fill out the survey. Thanks everybody for listening. I hope this was helpful for you. I know you have a lot of questions. Let us know how we can help, and we'll be in touch with all of you very shortly. Take care, everybody. Bye-bye.